But the instructions are that UT is not a permanent feature. But I'll make a positive statement tomorrow, that is day after. Because I'll have to meet
before Kashmir, Jammu and Kashmir.
Yes. Yes, not
Ladakh.
Ladakh would remain UT. That's what we have understood. But we'll meet personally, AG and me, and we will make a statement. But I must tell your lordships, so far as Ladakh, as I have already pointed out, that local body in terms of district development council elections took place in 2020. And so far as Ladakh is concerned, it consists of two units. Units is a loose word I am using. That is Leh and Kargil. Lord, election to Ladakh Autonomous Hill Development Council, Leh, is held in October 2020 for 26 seats. And for Kargil, it is going to be held on 10th of September 23. So Ladakh election would be over. But I may, my lord, your lordships need not open, my lord. It is volume 10, document compilation volume, page 763.
Document compilation volume?
Volume 10, page 763. But I am reading 4 lines from Lok Sabha and 4 lines from Rajya Sabha, because something said on the floor of the house has its own sanctity. Therefore, my lord, I am reading it. Lord, your lordship says, my lord, page 763, my lord, volume 10. Because the Honorable Home Minister introduced the bill and it was debated. It was debated for both the days.
This is Lok Sabha, this one?
This is Lok Sabha, my lord. What I am reading at page 763 is Lok Sabha. All members participated in the debate, and my lord, relevant is the last para. अध्यक्ष महोदय, मैं अनुच्छेद 370 की बात बाद में करूंगा. सबसे पहले मैं इस चर्चा में काफी सारे सदस्यों ने भाग लेते हुए कुछ चीजों के बारे में जानना चाहा है, कुछ मुद्दे भी उपस्थित किए हैं जिनका मैं सबसे पहले जवाब देना चाहूंगा. काफी सारे विपक्ष के सदस्यों ने कहा है, सम्मानीय सदस्यों ने कहा है कि यूटी क्या हमेशा के लिए है, यूटी क्यों बनाई गई है, यूटी कब तक रहेगी. सोएन ने भी कहा. मैं इस सदन के माध्यम से पूरे देश के सामने और विशेषकर घाटी और जम्मू, घाटी मीन्स वैली के लोगों के सामने स्पष्ट करना चाहता हूं कि जहां तक यूटी का सवाल है, परिस्थिति सामान्य होते ही उचित समय पर पूर्ण राज्य का दर्जा देने में इस सरकार को कोई आपत्ति नहीं है.
It's just read the last 3 words again. Is it say पूर्ण राज्य?
पूर्ण राज्य का दर्जा. I just read. मैं इस सदन के माध्यम
full statehood.
मैं इस सदन के माध्यम से पूरे देश के सामने और विशेषकर घाटी और जम्मू के लोगों के सामने स्पष्ट करना चाहता हूं कि जहां तक यूटी का सवाल है, परिस्थिति सामान्य होते ही उचित समय पर पूर्ण राज्य का दर्जा देने में इस सरकार को कोई आपत्ति नहीं है. मलोड 512 is Rajya Sabha, Malod. Here also, Malod, this question arose. But somewhere 10th line from the top, Malod, it starts with कई माननीय सदस्यों. But I am on page 162. I'm sorry, page 512. Your Lordship has one?
After that, after the English words, constitutional position?
No, उससे the same line. अगर सभापति महोदय की आज्ञा हो तो मैं पूरी कॉन्स्टिट्यूशनल पोजीशन सदन के सामने रखने को तैयार हूं। एक माननीय सदस्य ने पूछा कि कब तक यह यूटी रहेगा। मैं माननीय श्री सोएनसो और जिन अन्य माननीय सदस्यों ने यूटी के बनने पर आपत्ति दर्ज की है, मैं निश्चित रूप से उनको आश्वस्त करना चाहता हूं कि जैसे ही नॉर्मल परिस्थिति हो जाएगी, उचित समय आएगा, इसको फिर से स्टेट बनाने में हमें कोई एतराज नहीं। मैं आज इस सदन के माध्यम से जम्मू कश्मीर की जनता को भी कहना चाहता हूं कि जम्मू कश्मीर भारत का मुकुटमणि है और इसमें कोई मतभेद नहीं है। जब भी उचित समय आएगा, मगर आज जिस प्रकार के भाषण हो रहे थे, मुझे लगता है थोड़ा लंबा समय रहेगा, एटसेट्रा एटसेट्रा, क्योंकि इस भाषण इसके बाद घाटी में भी होने वाले हैं। दैट वाज माय लॉर्ड एन एप्रीहेंशन।
What's the date of this?
5th of August 2019, when reorganization bill was being considered. May I quickly, my lord, take your lordships through the judgments, my lord, on Article 3-4, whichever way, my lord, your lordships would like me to go. I'll read, my lord, only cite few judgments on
All right, let's
reorganization and 356.
All right, where are they, Solicitor?
My lord, 162. My lord, your lordships have
Which
read
compilation?
my written submission, volume 3, combined written submission. My lords have seen Article 3 and Article 4. The respectful submission is, my lord, and this, my lord, we, during discussion with Mr. Dwivedi, my lord, we came to know, Lord, the distinction is, this is the only state where it was not at par with the rest of the country, and now it is becoming the part. That is, my lord, the distinguishing feature which would never arise in case of any other state. Now, my lord, this UT, my lord, of Jammu and Kashmir came up for consideration of this honorable court. My lord, at page 162, the judgment of...
I closed the compilation volume, so I'll have to research find out where.
Volume 3.
I'm sorry?
Volume 3. Volume 3.
Which you are reading.
Yeah.
My written submissions. But what I've done is, so that your lordships may not have to shuffle through the judgment volumes, I have quoted the paragraphs I am relying upon, verbatim.
This para 85 onwards?
Yes, madam. No, madam. Para 85 onwards, yes, madam. I'm skipping the paragraphs. I'm just reading the judgments.
I'm just locating, I have the page, that's all.
Yes, yes.
Right.
I'll read the judgments, madam.
First,
Your lordships, I have noted the judgment of this court, my lord, in case of Jammu Kashmir. The present reorganization. Article 3 provides that Parliament may by law form new states and alter the area's boundaries.
Para 89.
I'm sorry.
Para 89.
Para 89. I'm sorry. May I read?
Yes.
Article 3 provides that Parliament may by law form new states and alter the area's boundaries or names of the existing states. The explanation 1 provides that in clauses A to E of Article 3, a state includes union territory. Thus, explanation 1 makes it amply clear that the power of Parliament under clause A of Article 3 to make a law to form a new state or to alter a boundary of a state includes a power to make a law to form a new union territory. Explanation 2 clarifies that power conferred by clause A on Parliament to enact the law to frame a new state includes a power to form union territory by uniting parts of any state or union territory to any other state or union territory. Now, kindly come to para 26, at page 163. On conjoint reading of Article 3, 4 and 239A, we find that Parliament, by making a law, can convert an existing state into one or more union territories. B. Parliament is empowered by law to create a body of legislature for the union territories of Puducherry and Jammu and Kashmir. Accordingly, subsection 2 of section 14 of Jammu and Kashmir Reorganization Act provides that there shall be a legislative assembly for union territory of Jammu and Kashmir. And C, even if law made by Parliament creating a body of legislature for union territories of Puducherry and J&K has the effect of amending certain parts of the Constitution, it shall not be deemed to be an amendment of the Constitution for the purpose. But if your Lordship sees holistically Article 3 and Article 4, and I am saying this academically, I am not pitching it, my lord, for this particular case. But there is nothing, if we read as a common scheme of, my lord, reorganization, that one state, for a good reason, the threshold of your lordship satisfaction would be higher, can be converted into UT. Because 4 says some incidental provisions can even include something which may otherwise amount to amendment, but would not be treated as an amendment under 368. Then, my lord, Pradeep Chaudhary, my lord, I am skipping. Your lordship.
1 and 2 were made applicable to Jammu and Kashmir.
Yes, but what happened was, during the first arguments of the petitioners, they pointed out the Article 3 as applicable to the state of Jammu and Kashmir, which provided that nothing can be done without consent of Jammu and Kashmir Assembly. Without pointing out to your lordships that before this Reorganization Act was placed before the House, the entire Constitution was made applicable. Therefore, that proviso goes. Now, what Article 3 your lordships have applied, my lord, when this reorganization took place. Lord, I hope I am able to make myself clear. What was shown was the earlier Constitution as applicable to Jammu and Kashmir, Article 3 as applicable to Jammu and Kashmir, which provided for a mandatory consent. But first, the President issued 272, CO 272, applied the whole Constitution, meaning thereby what we are reading now as Article 3 was Article 3 when reorganization took place.
What's the date of reorganization? What's the date of reorganization?
It was passed on 6th of August. In both houses. Lord, this is, Berubari is considered. Lord, Berubari, your lordships are aware, my lord, has no application. A part of India was being ceded to some other country. That was the concept. That was the fact situation arising in Berubari. There was a mistake in Berubari, which 5-judge bench in Ram Kishore notes and corrects. And thereafter, there is an amendment to the Constitution, knowing that now there was a mistake in Berubari. I'll show, my lord. Please come to para 91 at page 164. Only, my lord, the relevant parts I have quoted and I'll read. This is a 5-judge bench, my lord, speaking to my Lord Justice Gajendra Gadkar. Before proceeding to deal with the points which have been raised before us by Mr. Mukherjee on behalf of the appellants, it is necessary to advert to the opinion expressed by this court in Re the Berubari Union and Exchange and Enclaves, so-and-so. The Berubari Union at para so-and-so, with a view to correct an error which has crept into the opinion through inadvertence. On that occasion, it was urged on behalf of the Union of India that if any legislative action is held to be necessary for implementation of Indo-Pakistan Agreement, a law of Parliament relating to Article 3 of the Constitution would be sufficient for the purpose, and that it would not be necessary to take any action under Article 368. This argument was rejected. In dealing with this contention, it was observed by this court that the power to acquire new territory and the power to cede a part of the national territory were outside the scope of Article 3C of the Constitution of India. This court then took the view that both the powers were essential attributes of sovereignty and vested in India as an independent sovereign republic. While discussing the significance of the several clauses of Article 3 in that behalf, it seems to have been assumed that union territories were outside the purview of the said provisions. In other words, the opinion proceeded on the basis that the word state used in all the said clauses of Article 3 did not include the union territories specified in the first schedule. Apparently, this assumption was based on the distinction made between the two categories of territories by Article 1(3). In doing so, however, the relevant provisions of the General Clauses Act were inadvertently not taken into account. Under Section 358B of the said Act, state, as respects any period after the commencement of the Constitution, 7th Amendment Act, shall mean a state as specified in the first schedule to the Constitution and shall include a union territory. This provision of General Clauses Act has to be taken into account in interpreting the word state in the respect of clauses of Article 3, because Article 367(1) specifically provides that unless the context otherwise requires, the General Clauses Act shall, subject to any adaptations and modifications that may be made therein, under 372, apply for the interpretation of this Constitution as it applies for interpretation of an act of legislature. Therefore, the assumption made in the opinion that Article 3 in its several clauses does not include union territory is misconceived, and to that extent, the incidental reason given in support of the main conclusion is not justified. My Lord, after this judgment, my Lord, 18th Constitution Amendment is made. Judgment is, my Lord, 27th August 66. I'm sorry, the judgment is 1965.
What is the date in 1965?
Lord, I'll just give the Lordship may give me a minute. The amendment is, my Lord, 27th August 68.
27th August?
66. 27th August 66.
And just give us Ram Kishore's.
By which, my Lord, these explanations came to be added.
Right.
That state includes UT. That was, my Lord, result of this Ram Kishore Sen judgment. My Lord, if your Lordship would like to see where it is PDF volume 6, case compilation volume 6.
For what? Ram Kishore judgment.
Ram Kishore judgment. Your Lordship wanted Ram Kishore judgment?
Yes, sir, just the date. Just give us the date, that's all.
My Lord, 11th August 1965.
All right.
This is prior to.
Now, your Lordship